Today, I will be presenting the class review on the topic Guardianship, Adoption, and Acknowledgement of Paternity. So, first of all, I'll be dealing with guardianship, then I'll go on to adoption, and lastly, I'll deal with acknowledgement of paternity. Um, okay, so guardianship, we know that guardianship is the process where a person is entrusted with the duty to take care of the person, property, or both of a minor. For the purpose of guardianship under family law, there are basically two acts that governs it. The first one is Guardians and Wards Act 1890, and the second one is Hindu Minority and Guardianship Act 1956. So, as I have told earlier, guardianship deals with mainly two people. The first one is a minor and the other is a guardian. Section 4A of the Hindu Minority and Guardianship Act deals with the definition of minor. A minor means a person who has not completed the age of 18 years. Section 4 clause B defines the term guardian. A guardian means a person who has completed the age of 18 and he is taking proper care of a minor and his property and as well as his own. So according to Hindu Minority and Guardianship Act, there are different kinds of guardians. So the first kind is a natural guardian, and it is defined under section 4 clause C, and 4 clause C says that a natural guardian is a person who is defined under section 6 of the act. So according to section 6, if a child is legitimate, a natural guardian is the father of the child, and after him it will be the mother. And if a child is illegitimate, the natural guardian will be the mother, and after her it will be the father. One of the main case law regarding natural guardian is Geeta Hariram versus RBI. In that case, the constitutional validity of section 6 clause A of the act was challenged as it is violative of article 14 and 15, and Supreme Court held that mother can act as a natural guardian even if the father is alive. So the word after doesn't mean that the father has to be deceased. So coming to the next kind of guardian, the next kind is a guardian who is appointed by the will, that is a testamentary guardian. So the father can appoint a guardian, and after the death of the mother, that guardian will be the testamentary guardian of the child. Now coming to the other another type, guardian declared by a court or a certified guardian. So we know that section 13 of the act deals with says that the welfare of the minor is of paramount importance when it comes to guardianship. So for the welfare of the child, court can appoint a guardian, and this is still regulated by the Guardians and Wards Act 1890. Another type of guardianship is de facto guardian. So a de facto guardian is a person who shows continuous interest in the welfare of a minor's person and who also manages or administers the property of the minor without any authority of law. That is, the person does not have any authority of law, but still he is acting as the guardian of the child out of love and affection. Another type of guardian is ad hoc guardian, who is appointed on a temporary basis. And the final kind of guardian is guardian ad litem. That is a person who is appointed to defend the proceedings of a minor. So I've told about the kinds of guardian. Now I'll deal with the rights of a guardian. So a guardian has many rights when it comes to guardianship of a minor. Some of his rights are right to custody of the minor, right to determine the religion of the child, right to give proper education to the child, right to control the movement of the minor, right to reasonable chastisement, which means that the guardian can give reasonable punishment and scoldings to the minor. And he also have the right to represent the minor in litigations. He can get compensation for the legal expenses from the minor's property. He can also sue the minor after he attains majority to recover the expenses which he spent on his necessities. He can also refer the matter to arbitration if it is in the best interest of the minor. So these are the rights of a guardian. Coming to the removal of a guardian, as I have told earlier, Section 13 of the Act says that the welfare of the minor is of paramount importance when it comes to guardianship. So, if a person who is a guardian ceases to be a Hindu, he will be removed from his guardianship. Also, if a person becomes a hermit or an ascetic, that is, if he renounces the world, he will be removed from his guardianship. Also, the court can remove him if the court is satisfied that his interests are against the interest of the minor. So, that's all about the Hindu Minority and Guardianship Act. Now we'll deal with Guardian and Wards Act 1890. So this act is divided into 4 chapters. The chapter 1 deals with title, extent, commencement, etc. Chapter 2 deals with appointment and declaration of guardians. And chapter 3, in chapter 3, section 24 to 26 deals with guardian of the person. Section 25 deals with restoration of custody of the ward to the guardian. Section 27 to 37 deals with guardianship of property, and section 38 to 42 deals with right of supervisorship among joint guardians, removal of guardian, discharge of guardian, etc. And finally, chapter 4 deals with matters in nature of enforcement, appeal, and other miscellaneous provisions. So now we'll move on to Muslim law relating to guardianship. So in Muslim law, guardianship is called as hisanat. There are mainly 3 types of guardianship in Muslim law. That is, the first one is guardianship in marriage, second one is guardianship of person of a minor, and the third one is guardianship of property of a minor. So when it comes to guardianship of person of a minor, father is considered as the natural guardian, that is the legal guardian of a child. But a mother is given an important role when a child is in his younger age. That is, according to Sunni law, if the child is below the age of 7 in case of a male child, or if the child is below the age of puberty in case of a female child, the custody of the child is given to mother. In case of Shia law also, when a child is under the age of 2 in case of a male child, or a child is under the age of 7 in case of a female child, the custody of the child is given to mother. So that's about the guardianship in person. Now we'll deal with guardianship in property of a minor. So in the guardianship of property of a minor also, there are 4 types of guardians. That is the legal guardian, testamentary guardian, statutory or certified guardian, and de facto guardian. A legal guardian is the father of a person, and in the absence of father, it will be the executor of father, paternal grandfather, executor of paternal grandfather, etc. In case of guardian, the next type is guardian appointed by will. That is a testamentary guardian. A guardian can be appointed by father, and in his absence, a guardian can be appointed by a grandfather to deal with the property of a minor child. The other type is a statutory guardian. A statutory guardian is normally appointed by a court in the absence of a natural and legal guardian. The last type is a de facto guardian. A de facto guardian, as I have told earlier, is a person who has no authority of law but acts as a guardian out of the love and affection to the minor child. So when it comes to Christian and Parsi law, they do not have a specific guardianship act dealing with the guardianship, and it is normally dealt under Guardian and Wards Act 1890. So now we'll move on to the topic of adoption. As we all know, adoption is the admission of a stranger by birth to the privileges of a child by a legally recognized form of affiliation. As far as adoption in India is concerned, there are mainly 3 statutes dealing with adoption. The first one is Hindu Adoption and Maintenance Act 1956. It deals with the adoption among Hindus, Jains, Sikhs, or Buddhists. And the second one is Guardians and Wards Act 1890, which deals with the adoption among foreign citizens, NRIs, and Indian nationals who are Muslims, Christians, or Jews. And the third statute dealing with adoption is the Juvenile Justice Protection and Care Act 2050. The act of adoption can be broadly classified into 2. That is, first one is within country adoption, and the second one is inter-country adoption. Inter-country adoption is dealt under Juvenile Justice Act through an agency called Central Adoption Resource Authority. In the case of Lakshmikant Pandey versus Union of India, Supreme Court gave the guidelines for adoption. Now we'll deal with adoption among Hindu adoption in Hindu law. Okay, section 6 to 17 of the Hindu Adoption and Maintenance Act deals with some of the important topics like who can adopt, what are the essentials of a valid adoption, conditions of male and female to adopt, who can be adopted, what are the rights and relationships among parents and the adopted child, etc. Now, moving on to necessary requirements for a valid adoption, it is given under section 6 of the Act, and the necessary requirements are that the adopting parent or the person should be legally capable of adopting the child, and also the person who is giving in adoption should be legally authorized to give in adoption, and the person who is adopted should be capable of being taken into adoption. So these three are the necessary requirements of a valid adoption. Now, coming to the capacity of a person, capacity of persons, we'll first deal with the capacity of persons taking in adoption. That is the capacity of person who are taking the child in adoption. So section 7 deals with males who are adopting a child, and section 8 deals with females who are adopting a child. A person who is adopting a child should be of a sound mind, and he should not be a minor. In case of a male, if he has a wife living, he shall not adopt except with her consent. In case of female also, if her spouse is living, she shall not adopt except with his consent. So, but if the spouse is has completely renounced the world, or he has ceased to be a Hindu, or he is unsound, he is of unsound mind, it is not necessary to gain the consent of the spouse. So, moving on to the other topic, that is who can give in adoption. That is who can give their child for adoption. Section 9 deals with who can give in adoption. That is the father or mother or guardian of a child, or a person who is declared by the court of competent jurisdiction can give in the child for adoption. Okay, now who can be adopted. That is a child can either be a girl or a boy, but he or she should be a Hindu, and also he or she should not have been adopted any time before, and the age of the child should be below 15 years, and the child should also not be married. So if these conditions are satisfied, the child can be adopted. Now, coming to the effects of adoption, it is given under section 12 of the Act. An adopted child shall be deemed to be a child of his or her adoptive father or mother for all the purpose with effect from the date of adoption. And all the earlier ties of that child with his previous family will be severed or replaced through the adoption. Also, the property vested with the adopted child before the adoption shall continue to vest, and the adopted child should not divest any person of any interest which is vested in him or her before the adoption. Also, section 15 says that a valid adoption shall not be cancelled for any reason whatsoever. Section 16 says that the presumption as to registered documents relating to adoption, that is the presumption is that the adoption is valid until and unless it is disproved. Section 17 deals with prohibition of certain payments while during adoption. That is, no consideration shall be given for adoption, and any person who is violating the said provision shall be punishable with an imprisonment up to 6 months or with a fine or both. Now we'll move on to adoption under Muslim law. Under Muslim law, adoption is not recognized, and in the case of Muhammad Al-Had versus Muhammad Ismail, it was held that the acknowledgement of paternity under Muslim law is the nearest approach which is relating to adoption. So there is a difference between adoption and acknowledgement of paternity. That is, in adoption, the child who is adopted is called as the son of another person, but in the acknowledgement of paternity, the child who is adopted must not be known as the son of another, but as the son of the acknowledged person only. So coming to the adoption under Parsis and Christian law, the personal laws of these communities do not recognize adoption, but Christian can adopt by the provisions under Guardians and Wards Act, and he can approach the court for adopting a child. Now coming to the last topic, that is acknowledgement of paternity. Acknowledgement means a recognition of something as being bona fide. We know that paternity of a child can be easily established, and it is acknowledged at the time of birth of the child himself. But in case of paternity, it is not that easy to acknowledge the paternity of a child. So the acknowledging father should acknowledge the child, and the essentials of acknowledgement are the acknowledging father should be 12 and a half years older than the acknowledged child, and the child should be of an unknown paternity or a place of birth. There are mainly two types of acknowledgement. The first one is formal acknowledgement, where the father recognizes the child as his own, and it is by a formal written document which is signed by two witnesses. And the second type is informal acknowledgement, where a declaration is merely made by the words spoken. So that's all for today. I have dealt with the topics of guardianship, adoption, and acknowledgement of paternity. Thank you.